Good afternoon, friends. In the continuation of our AB exam preparation, we were discussing about the CPC session 1 and now we will continue with the CPC. The questions or the pleading means. What is pleading? Pleading means it is a plaint and written statement. Pleading actually defined in the CPC order 6 and with respect to the plaint it refers in the order 7 and written statement in order 8. So if you remember these two, we can refer back to the Bail Act. On the failure of the written statement under the order 8 rule 10 of CPC, pass any other order for striking the decree or may pronounce a judgment at once, any of the above. All of these are applicable. A resides at Shimla, B at Kolkata, C at Delhi. A, B, C being together at Banaras, B and C make a joint promissory note payable on demand and delivered to A. A may sue B and C at any of the places, Banaras, Kolkata and Delhi, because the transactions were held and the persons were residing at so and so place. So all of the above are true. In a written statement, the defendant can claim a set-off or a counterplant, both A and B. In which of the following cases set-off can be claimed? A owes the partnership firm B and C 1,000 rupees. B dies. C is surviving. A sues C for a debt of 1,500 due to in his separate characteristics. C wants to set off the debt at 1,000. So this is the answer in case of a set-off can be claimed. Under Order 33, an indigent is allowed to prosecute any suit. He is satisfied certain conditions. Which of the following conditions? He is not entitled to property worth 1,000 rupees. A decree can be transferred for execution from another court if the judgment debtor actually and voluntarily resides or carries business personally, works for gain within the locality and limits of the jurisdiction of the court. If the judgment debtor has property sufficient to satisfy the decree within the limits of that court, if the decree directs the sale or a delivery of the immovable property situated outside the local limits of jurisdiction of the court, which is positive. All of the three are applicable. In which of the following cases it was said that unless a right of appeal is clearly given by a statute, it does not exist? So this is said in the case of Zair Hussain Khan versus Khurshid Jain. A reference can be made during the pendency if the subordinate court refers the case to the higher court for the latter's opinion on question of a law. Here the reference on a question of law. Under section 115, in the exercise of its revisional jurisdiction, High Court can do which of the following? High Court can call for the record of any case which has been decided by any court subordinate to the High Court. Under section 114, a person can apply for the review of the judgment when he is aggrieved by the decree or order from which appeal is allowed, but no appeal is allowed. He is aggrieved by a decree or order from which no appeal is allowed. He is aggrieved by a decision on a reference from the court of the small cases. All of the above he can appeal. Under which section of CPC option for settlement of the dispute is provided outside the court? This is the alternate dispute resolution, section 89(1). Section 10 of the CPC does not apply when a previous suit is pending in the court, when previous suit is pending in a foreign court, when previous suit is pending in another court in India, when the previous suit is pending in a court outside the establishment by the government. Here it is answer is when previous suit is pending in foreign court, section 10 does not apply. The principles of res judicata is a mandatory provision. The time by which has begun to run can be stopped in case of, it cannot be stopped in case of minority, insanity, idiocy. So answer is none of the above. So wherever we have a doubt, we better refer to the concerned Bail Acts and we get the correct answer, particularly when the answer appears to be none of the above. Objection as to non-gender or a misgender of the parties under Order 1 Rule 13 of CPC It should be taken at the earliest possible opportunity or shall otherwise it shall be invalid. Objection as to the place of the suing. This can be only taken before the court at the first instance at the earliest possible opportunity. On the retirement, removal or a death of a next friend under Order 32, Rule 10 of CPC, the suit is liable to be stayed. Section 5 of the Limitation Act applies. It is not applied to suits, execution or election petitions. So answer is none of the above. So refer to the Section 5 of the Limitation Act. A is in possession of the property claimed by B and C adversely. A does not claim any interest in the property and is ready to deliver it to the rightful owner. Then A can institute an interpleader because it is A is not owner and it is between the other parties. So interpleader can be filed. What is the period of the limitation prescribed for the suit instituted by a mortgagor to recover the possession of the immovable property mortgage? 30 years is the period of the limitation in case of the mortgage. Section 12 to 15 of the Limitation Act 1963 provides for the exclusion of the time in computing the period of the limitation prescribed by law. Which of the following falls inside the ambit of the exclusion? Day on which the judgment order is awarded is excluded. Time during which the stay injunction is operated is excluded. Time during which the defendant had been out of India is excluded. So all of the above are excluded. Period of the limitation for the execution of the order of maintenance is it is 1 year from the date by which it becomes due. Where a territorial jurisdiction of a court is transferred after passing a decree, an execution application may be filed in a court which had passed the decree or in the court which has a territorial jurisdiction. In the both cases it can be done. When a decree is transferred for execution from one court to other court, if the decree holder has a reason to apprehend that the judgment debtor will depose his property before it is attached by the court, he may apply to the court by which a passed or decree to issue a precept to attach the property at once. Where the right to the discovery or the inspection sought depends on the determination of any issue in the suit, the court may try to issue a preliminary issue before deciding upon the right to discovery of the inspection. This is a preliminary issue. Identify the case where set-off can be pleaded. The claim for the unliquidated, suit for recovery of a ascertained amount, suit for some legal non-recoverable, none of the above. Suit for recovery of the ascertained sum of the repose. In case of a set-off, it has to be ascertained correctly what is the amount. A railway company is in possession of goods as a consignee. It does not claim any interest in the goods except the lien of wharfage, demurrage or a freight, but rivals' claim have been made by B and C adversely to each other. Then A can institute for an interpleader suit to settle the issue. Period of the limitation for execution of order of maintenance is 1 year from the date by which it becomes due. What is the period of the limitation to file a suit for the compensation of a false imprisonment? It is again 1 year within which the case has to be filed. As per Section 19 of the Limitation Act, if any payment is made on account of a debt before the expiration of the prescribed period by the person liable to pay the debt or by his agent duly authorized in that behalf, a fresh period of limitation starts running from when the creditor demands, is the right answer. In the judgment of the Supreme Court, in case of a Salem Bar Association versus Union of India, the Supreme Court had requested this committee headed by Justice Jagannatha Rao to prepare a case management formula. Justice Jagannatha Rao was asked to prepare a case management formula. A resides at Delhi and B at Agra. B borrows rupees 20,000 from A at Benares and passes a promissory note to A payable at Benares. B fails to repay the loan. A may sue B at Benares or Agra. Benares is a payable place, Agra is the one place A lives. So it can be at Benares or Agra. General principles of a waiver that provides that failure to raise the objection in the court of the first instance and at the earliest opportunity shall prevent the defendant from raising such objection at subsequent stage, and the judgment would not be vitiated on the grounds of the absence of the territorial or a pecuniary jurisdiction. This is reflected in the section 21 of CPC. Claim made by the defendant in a suit against the plaintiff is called counterclaim. Interpleader suit is dealt with which of the sections of the following CPC? That is, section 88 deals with the interpleader suit. As required by the section 80 CPC, the suit can be instituted after the expiry of the 2 months notice. Under section 2 of CPC, rejection of the plaint is called a deemed decree. Rejection of the plaint is also a decree. It is deemed decree under section 2 of 2. Ratilal versus State of Bombay is a popular case in the point of doctrine of Cyprus. Ratilal case is a doctrine of Cyprus. Pick out the case under section 58(1)(a) in which arrest or a detention of the civil prison is not maintainable if the judgment debtor where the decretal amount does not exceed 2,000. A precept seeks to prevent alienation of the property. Precept is always to seek the alienation of the property. Rule 90 of the Order 21 deals with the post-sale irregularities causing substantial injury to the judgment debtor. Rule 90 Order 21, it deals with the post-sale irregularities causing substantial injury to the judgment debtor. The place of suing in a suit for a partition will be within the court jurisdiction, that is where the immovable property is situated. Appeal against a decree or order can be filed in High Court within 90 days. 90 days is a limitation period for the appealing the decree. Where before the expiration of the prescribed period for a suit or application in respect of any property or right, an acknowledgement liability is respect in such a property or right has been made in writing signed by the party against whom such property of the right is claimed, or by any person through whom he derives his title liability. In such case, a fresh period of the limitation shall be computed from the time when the acknowledgement was so signed. The period of the limitation for an action by a principal against his agent for movable property received by the latter is not counted for 3 years. Existence of 2 suits by parties litigating under the same title, one previously instituted which is pending at present and other filed later, wherein the matter is in issue in the subsequent filed suit is directly or substantially in issue with the other, then the relief claimed in the subsequent suit can be effectively passed by the court of previous instance. Section 9 deals with this, where you take the stay on the proceedings. Where there are mutual debts between the plaintiffs and defendant, one debt may be settled against another. This is called the set-off. An attachment before judgment of order is taken away, that is a power to alienate the property. 3 pillars on which the foundation of every order or injunction rests are prima facie case, irreparable injury, and balance of convenience. A reference is to enable subordinate court to obtain a non-appealable cases of the opinion of the High Court in absence of the question of the law, thereby avoid the commission of an error which could not be remedied later on. Where the appeal is not there, the lower court can always take the opinion of the higher court reference so that case can be settled in a correct way. Who decides as to which of the several modes she or he will execute the decree? It is by decree holder who can execute the decree. Where a party to a suit requires information as to facts from the opposite party, he may administer to his adversary a series of questions. This is called interrogatories. Representative suit is a suit filed by or against one or more persons on behalf of themselves or others having the same interest in the suit. If there are more than one person is having the same interest, one of them can file a case which is called the representative suit. A person appointed by the court to protect or preserve and manage the property is called the receiver. The provision under CPC that relates to the suit by indigent is covered under the Order 33. Order 33 covers about the provision for the indigent person to file a suit. Section 5 of the Limitation Act 1963 enables the court to condone the delay in filing an appeal or application on sufficient satisfaction of the sufficient cause. Limitation period prescribed in filing a suit by a mortgagor to recover the possession is 30 years. In case of a property, it is 12 years. Foreign court under section 5 of the 2 of CPC is a court which is situated outside India, the authority of the government of India. A judgment under section 9 of 2 means it is a statement of grounds of an order or a decree. A judgment is a statement of the grounds of order or a decree which is defined under 9 of section 2. Principle res sub judice. Res sub judice means already a case is there pending, a decision cannot be taken. That is covered under the section 10 of CPC. Doctrine of res judicata contains in the section 11 of CPC is based on nemo dip bis vexaret pro no idem causa interest re publicate sit finis alicium. Both A and B are correct. The principles of res judicata applies. It applies only about the parties who are into the suit. It is not applicable to the co-defendants or co-plaintiffs. Validity of a foreign judgment can be challenged under section 13 of CPC in a civil court only. Any validity of the foreign judgments can be challenged in civil court only under section 13. Under section 15 of CPC, every suit shall be instituted in the lowest grade of the court. So any original case has to be filed in the lowest grade of the court. X residing in Delhi publishes a statement of defamatory to Y in Calcutta. Y can sue X both at Delhi as well as at Calcutta. A suit for the damages for the breach of contract can be filed at a place where the contract was made, where the contract was to be performed, or anywhere in India. So both A and B, where the contract is made or where the contract is to be performed. These are the two places a suit of damages can be filed. In every plaint under section 26 of CPC, facts should be proved through affidavit. Affidavit is to prove the facts as per the section 26 of CPC. The existence of the statute of the limitations is due to long dormant claims have more of the cruelty than the justice in them, or defendant may have lost the evidence due to the dispute in the state claim, or the persons with the good causes of action should pursue them with a reasonable diligence. All of these are applicable for the existence of statutes of the limitations. The Limitation Act is applicable only to the civil suits. Okay friends, with this I think we have completed CPC based on the previous year's question papers, and the next session we will be